Just very briefly, he's going to have 10 minutes to give a snapshot in his story. His story is very, very complex. But what happened was that he found himself working in a dangerously understaffed ITU department. He blew the whistle, and the way that the government found to control what he was trying to do for the sake of patient safety actually ended up depriving 54,000 doctors of whistleblowing protection. This then led on to, yes, obviously consequences. And what I would like to say, even though I am a member of, well, I'm going to be a member of the BMA Council, I think this is a matter of fact, and it's widely known that the BMA did, for whatever reason, decide that it would not help him with his personal case, but it also decided that it would not help him with his fight for statutory whistleblowing protection for all junior doctors, including the 40,000 BMA members who are junior doctors. Are we ready to go, Chris? Yeah. So I'd like you all to give a warm welcome to Chris, don't you?
Hello everyone. Hello everyone.
Chris, stand to the side of it.
Oh yeah. I'll stand
Down this side.
Yeah. I can't actually quite believe that I've been invited by 3 members of BMA Council to an event just around the corner from a BMA conference, and I'm also sat next to Edwin Jesudason and Bob Gill, who's just shown a great NHS Heist trailer. So I really do have to pinch myself. It shows progress within the BMA. I think we should start getting excited, the fact that this lot got elected into BMA Council. Not because they are amazing people that will do amazing things, but it certainly is a change, the way decisions are beginning to be made in that organisation. Anyway, imagine this. You are a junior doctor, and you decide that you have to raise safety concerns. Now, these aren't insignificant safety concerns. You are the most senior on-site ICU doctor, and you are working at night in an ICU that departs...
Turn down the volume a bit, Chris.
Oh, yeah. Sorry, I can't do that. You're working in an ICU at night that departs significantly from what national standards say are safe. And in addition to that, there are 2 serious incidents involving the deaths of 2 patients associated with those protected disclosures, or whistleblowing disclosures. In addition to that, it's a trust, one of the only trusts that have ever gone bust as a result of 2 PFI hospitals, not just 1, 2 PFI hospitals within the South London healthcare. 2 of the worst, I know Alison will be proud of me, 2 of the worst negotiated PFI deals in the country were found in this one South London trust. And in my time there, this wasn't my fault, it actually went bust and got reorganised by the Secretary of State for Health. And I think that is key, because I think this sort of pathological obsession the NHS has with its reputation was more heightened in those circumstances when I was there. Anyway, so you have this junior doctor raising safety issues. And then you have, instead of dealing with these fairly objective ICU staffing issues, we're talking numbers nowhere near national standards. They don't really have a leg to stand on. But instead of dealing with these issues and those 2 deaths, 2 NHS organisations team up to make a load of allegations against me to make it less likely for anyone to listen to anything I say. And it worked very well, because it ended my career. It resulted in a messy employment status dispute that ended my career. So I went along to my union and said, look, this is my evidence, this is my e-portfolio, these are my supervisor reports, these are the deaths, these are the ICU ratios. Surely something needs to be done. I didn't really know anything about whistleblowing, but they said, of course, you need to do whistleblowing cases against the trust, these 2 NHS organisations. And they sent it to their external law firm, Gately, and it passed the merits assessment. So it did pass 1 merits assessment, that's what they don't like to tell you. And they engaged lawyers, and my BMA rep made legal threats against both of these, the trust and these NHS organisation. And then, 5 days before a deadline, suddenly my strong meritus case suddenly became a very weak case, and the lawyers were withdrawn. 5 days before a legal deadline, a crucial document got lost or destroyed. The BMA position is it never existed, and that's a formal trade union record of an investigation meeting. So it's not the sort of thing that wouldn't exist. but the BMA can't produce it. And then, even if you don't think that's a bit odd, my BMA rep himself went missing. So not only his record, and he accidentally decided that he didn't want to work for the BM anymore that afternoon, and was never seen working for the BMA. You can't make this up. I'm pretty confident in what I'm saying as well. So I'm not saying anything that I'm not absolutely sure that I can show to be true. You can consider that statement with what I say. So you can imagine this. There's me, dumped by my union, got a wife, got 2 kids, and I'm thinking, what on earth's going on? So, undeterred, we find a lawyer that's suffered with me, I'd say, over the last few years, and we build a case in five days and present it to the London Self-Employment Tribunal. And then I have to wait 6 months. I'm doing A&E locums, just keeping my family supported through this. And then the big day arrives, February 2015. Finally, I get to show my safety concerns and defend myself against all these allegations. And then, instead of arguing the case on the facts, I kid you not, the NHS argues every junior doctor out of statutory whistleblowing protection and tells me the case can't be heard. That crazy argument works, and the case gets chucked out. And then in addition to that, the union, the BMA, spin this as me losing the case. So they're not honestly saying that the case has never been heard and there's a problem with whistleblowing law. It is spun that I've lost the case, and then this problem with whistleblowing law that's prevented the case being heard is denied, not only by the BMA, but by the government. That's a pretty bad situation, isn't it, to be in? But then that's where it starts to get very interesting. We launch a crowdfunding campaign, and over 3.5 years, 4,000 people donate £240,000. And we actually expose and solve these ridiculous arguments that have prevented the case being heard. And last year in the Court of Appeal, we had a landmark victory in the Court of Appeal, and just last month, HE finally gave up and conceded what they've been up to for the last 3 years. And to stop me going into the details in open court, paid me £55,000 to go away as a down payment for a preliminary hearing. So I can't begin to tell you what, my wife is just at the front there, I can't begin to tell you what that is like. I mean, I'm listening to Edwin, nor can he. He can't put into words. He in very, very cool, calm and collected fashion, he has given you an outline of the facts. But we can't tell you what it's like. But what we can do, or certainly what I'm going to try and do, you said 50 minutes, by the way, is tell you what this should mean to you and what you guys can learn from it. Because that's constructive, isn't it? So, as Alison alluded to, crushing and undermining someone who tells you something you don't want to hear. There's nothing new about that. That's been going on to the dawn of time. So this idea that this is a new thing that the NHS is going to solve is with a culture change is fanciful. The real question here is, what are you going to do about it if you're a leader or an organisation when this inevitable thing happens? And we know what the NHS's answer to that question is at the moment, and it's pretty poor. It's dishonest, it's dangerous, and it goes nowhere. And if we've looked at mid-staffs, if you weren't listening during mid-staffs, you had the Francis Freedom to Speak Up review, you had the Hooper report that dropped the GMC right in it in relation to whistleblowing. And again, you've had fairly recently the Gosport scandal that reminds us all what the problems are. But this situation of crushing the whistleblower was actually considered in the 1990s by Parliament. And the BMA, oh yes, right slide. So in the 80s and 90s, there were various scandals, and these were just the ones we knew about, subsequently Savile and various others. These were considered by various inquiries, and it was found that people largely knew what was going on at the time of these. And it was also found if people had spoken up, or the people that had spoken up were listened to, great harm to individuals and financial harm could have been greatly reduced. So you had a situation where the Public Interest Bill was introduced to Parliament, and it ascended through Parliament with virtually no resistance from either of the parties, and also significantly the trade unions and the employers, the Board of Institute of Directors. So it was passed into a statute, the whistleblowing law, the Public Interest Disclosure Act. So the BMA would like you to believe that this is just a new thing. This was all decided in the 90s, who was going to be protected. Whistleblowing sounds dramatic, doesn't it? It sounds like it's not relevant to your average doctor, although that has begun to change with Hadiza Baragaba, because I think it's forced us all to consider what we have to do if we're placed in dangerous situations. But whistleblowing isn't dramatic. It's not being a snitch, and it's not dramatic revelations. It's merely, in the context of medicine, providing actual information and doing it in the right way. And in return, you get some kind of protection. Now, whether that protection is worth having is a separate issue, and I'm not going to go into that today. But again, Parliament was very, very clear what whistleblowing was, and it was to identify people that were acting in the public interest and to identify people that were being responsible with the information and to offer protection. And it made it very, very clear, this is directly from the Hansard transcript, who was protected. And in the context of the NHS, it's everybody. And in particular, students, trainees, and individuals in hospitals that aren't normally covered by employment law. So, if Parliament had been so clear, how could it possibly be, in the middle of a junior doctor's dispute in 2015, the same year as the Francis report, Freedom to Speak Up With You, weeks after it, the same year that Dr. Hadiza Baragaba gets convicted of gross negligence manslaughter, how can it be that the government got away with arguing the entire junior medical profession out of statutory whistleblowing protection? How can it be that the government and the HE got away with submitting things in court that directly contradicted Parliament's clearly stated intention for whistleblowing law? And the answer to that is very, very quick, and it is the BMA.
Yeah.
So how did they do it, I hear you ask? Well, HEE spent £100,000 on creating essentially a gap, a lacuna. And my friends hear a lot about lacunas and gaps in law. But the important thing here, it was a totally false gap. It wasn't based on anything. It wasn't based on Parliament's intention. It was based on incredibly flawed legal arguments. And I just want to, because this is how this gap came about, it's absolutely crucial. And I remind you also that this was in the middle of a junior doctor's dispute. This is gold dust if you're in an industrial dispute. So HE created this gap in law by clearly misrepresenting Parliament's stated intention, by saying that junior doctors' relationship with HE and their career were consciously chosen to be outside of whistleblowing law. They used arguments also more scandalously to claim that one particular worker couldn't have whistleblowing protection for more than one organisation. And that not only pushed all junior doctors out of whistleblowing protection, it pushed out 800,000 agency and contractor workers across multiple industries. So industries like the City of London, the financial sector, that may have several legal entities involved in a person's employment. For example, in banking, a subsidiary of a bank might employ a worker, and then another legal entity in the bank might actually be where the worker operates. All of those were argued out of whistleblowing protection, basically because NHS leaders and BMA leaders are out of control. And I'm making it's a very serious allegation for me to claim that HE misrepresented Parliament. So I just wanted to put what was reported in court by the press next to the Hansard transcript from the House, and you can see that the Parliament consciously chose for doctors to be outside of whistleblowing protection, being submitted in court by the HE barrister, and that being reported in the New Statesman. And the Hansard transcript that I've previously referred to, showing quite clearly that that isn't the case. Now, despite the BMA trying its best in the middle of a junior doctor's dispute to deny all this, you know, Chris Day's a dodgy geezer and it isn't, he's lost his case. People made, and I'm very, very grateful to the people that made the effort to look into this, and it became very, very clear that HE had played a game to stop the case. Well, clear to some, not the BMA JDC, but it became very, very clear to large numbers of people that HE had played a game. It also sort of brought to light HE as an organisation. And this wasn't just about whistleblowing. This was about an organisation that has de facto power as an employer over 54,000 doctors being able to get out of any kind of accountability. The lacuna or gap in the law denied by the BMA before they accepted it in August 2016 was clearly described in judgments, as you can see. Mr. Recorder-Luba QC describes clearly the problem with HE. And if you go further down, Lord Justice Elias describes the problem, which isn't just the whistleblowing problem. This is a problem junior doctors have with HE. And it's basically, it doesn't matter even if what the doctor says is true about HE. It doesn't matter because we're HE. That is a serious problem for all junior doctors, and that hasn't been dealt with yet. So what did the BMA do? Well, they took the case, they withdrew from the case 5 days before a deadline, and they actually released statements that have been found not to be true, to undermine our appeals to actually correct this for all junior doctors. But not only junior doctors, the victory in the Court of Appeal actually corrected the law for 800,000 contractor workers and the agency workers. And we had statements from Mark Porter saying that the case was clearly without merit and no longer relevant, and him asking JDC members to share them on social media, or he said that the information wasn't restricted. And so they did. And then we have this victory in the Court of Appeal that really shows the BMA position, again, not just for whistleblowing protection for junior doctors, but for 800,000 contractor agency workers, for those passionate about trade unions. And their position was completely wrong. So our victory in the Court of Appeal proved we were right, and the BMA was wrong. And I know I'm running time, so I'm going to speed up. So these games that I described, played by HE, misrepresenting Parliament and arguing agency workers and junior doctors out of whistleblowing law. There was another twist to this that I found out weeks before the hearing, and it's that HE kept a contract that it had between the trust that I was at, called a learning development agreement, that basically imposes loads of conditions on the trust on how they are to manage junior doctors when they come and do training at the trust. Now, the HE had to accept that they had hidden this, or not hidden, they say, didn't choose to disclose it to the Employment Tribunal in 2015, the EAT later in 2015, and in the Court of Appeal. So they kept a contract really showing that they had this substantial influence that we've spent 3.5 years and over £200,000 arguing about. They actually had a contract that clarified the situation. And that was really the main reason the case collapsed for them on the 14th of May, because they never had a chance. I mean, they never had a chance on the facts anyway. And I think that when a junior doctor rocks up to an employment tribunal and goes home with £55,000, and that's not even the real case, that's just a preliminary point, you know someone's been naughty. I don't think you need more understanding than that. But it's there. So I was sat there an hour into this hearing that I'd been waiting 3.5 years for, and I sent this tweet saying HE had caved in, and I must say it's a very surprising tweet for me to send. I'm going to there was a controversy about the kill switch that we haven't got time for.
More time.
More time.
More time.
Yes. Chris, continue. Mention
Okay.
the kill switch.
Okay, so in 2000, I mentioned about the BMA denying that this gap in the law in 2015, and then weeks before the junior doctor contract had to be imposed, suddenly changing its position and accepting this gap in the law, and then within a day claiming to have solved this gap in the law without going to court or without going to Parliament, which you can't really do unless you're the BMA. And so they came up with essentially a section of the contractual agreement that most lawyers that aren't part of the BMA chambers think that it's unlikely to work or be accepted by a High Court judge. And even if it is accepted by a High Court judge, a High Court is nowhere for a junior doctor to be settling disputes about their ARCP. As Mr. Jesudation will tell you, if you lose, you end up not just losing your case, you end up losing your house. And in fact, Parliament never intended for workers to have those kinds of conversations in the High Court. But the BMA, in an attempt to, in my opinion, I think I'm on solid ground when I say to cover up their actions in 2015, came up with this magical solution to bridge a gap that they'd spent a year denying so that they could impose a contract, because they did a survey, and one of the key objections to the contract that essentially was rejected by the membership was that it didn't have whistleblowing protection. So they must have thought very, very hard, oh, so people are beginning to believe Chris Day, we're going to have to do something, what can we do? So this contractual whistleblowing agreement had also inserted in it a kill switch, and that's paragraph 11 in it, where it says if a junior doctor obtains statutory whistleblowing protection, the contract self-destructs. Now, this sounds very like something I might come up with, a kill switch. It's not me. I have to give the credit to the HE barrister, Angus Moon QC, because the first 10 minutes of the hearing was him describing this kill switch. He took the judge to paragraph 11 of the whistleblowing agreement that the BMA concocted, and clearly said that he pressed the kill switch, that this case pressed the kill switch on it. This tweet. So I was pleased when I heard that, as you can imagine, after 3.5 years. And so I tweeted this. HE have caved in and said that they are an employer of all junior doctors. They have operated the kill switch on the contractual BMA whistleblowing agreement. We will now apply for costs as they kept crucial evidence concealed. My whistleblowing case will be heard. Didn't go down too well in BMA House, that tweet. And so when we re-entered the court a few hours after us haggling about the £55,000, it was suddenly announced that the kill switch hadn't been pressed. And my tweet was referred to, but it wasn't really denied. It was more that Chris Day sent this tweet. Anyway, so the position went, I would describe it as a barrister pressing the kill switch and then wishing he hadn't. Then I found out about this on Twitter, and it seemed that at the BMA Junior Doctors contract, the Junior Doctors Conference. What's that?
So it's our annual conference for the Junior Doctors Committee and members of juniors.
Yes, so they did this motion here to offer me congratulations, but then didn't tell me about it. So this is news to me. We found out that I was offered congratulations, but it hasn't come yet. So I'll be waiting a long time. This is an important slide, but I can't do it justice. But it's this question about, so we want statutory whistleblowing protection. Is it worth having? Edwin has done a brilliant job sort of illustrating the pitfalls of it. But it isn't protection, it's an employment right. Even if And that's what's caused all the problems they were with me. They're trying to deny that I was employed by anyone. But that's what it is. So it isn't protection. It's not a shield. There is no police force. If the baddies are after you because you've said something and annoyed someone, they're not going to come wading in. What might happen is if you're forced out or dismissed and you've got the money and you can cope with the paperwork, in 6 months' time you can go to an employment tribunal and fight 4 NHS lawyers an employment tribunal claim. And as Edwin has really said, it really isn't about whatever you whistle blew about. It's usually about all the allegations they make against you and having to discuss all of that. So it isn't really protection. I would say it's definitely not the police shield. That's what they would like you to think it is, but it's much more likely it's that, except that it hasn't got a hole in it anymore. So maybe it's valuable what we've done. So, this is my last slide, I promise. So I'm a member of Team Hadiza and obviously feel very passionate about her plight and what's happened to her. And I want to just contrast the NHS whistleblowing problem with scapegoating. What's happened to Hadiza is obviously connected more to the medical profession than my case, because I imagine most people wouldn't regard them as whistleblowers, but could well see themselves putting on a brave face and soldiering on in an unsafe situation. But scapegoating and the NHS whistleblowing problem are different, but at their essence they have the same thing. And it's, again, what Edwin was saying. It's about shifting the focus of system problems, shifting the focus of organisational problems and the decisions of powerful leaders, and focusing on a narrative about an individual, the scapegoat, the whistleblower, and then having a long old conversation about whether they are a goodie or a baddie, in the hope you will forget about what it's all about. And with that in mind, remember that ICU, remember that's nowhere near ICU safe staffing, remember those 2 dead patients, and remember those 2 PFI deals that have taken the DGH away from an entire London borough. Bexley no longer has a hospital, no longer has an ICU, it no longer has an A&E. That's what this is about. It's certainly not about little old me.